Ready, start. These orders are generally dictated in open court immediately after a hearing is over. Full stop. On the other hand, if in any given case the judgment could justifiably be reserved after hearing of extensive arguments, it would not be proper to criticize a learned judge if he dictates the judgment in open court, notwithstanding the length of time to be taken therefore. Full stop. As per the ordainment of Order 20th, the learned judge would be perfectly justified in doing so. Full stop. In such cases, it could roughly take any time between 20 minutes to a couple of slash few hours or even more spilling over to the next day, within bracket in rare cases, bracket close, to accomplish the task. Full stop. This approach could result in the board, within bracket, if it is heavy, bracket close, getting choked and the remaining cases on the board having slim chances of being considered. Full stop. As the saying goes, necessity is the mother of invention. Full stop. The necessity to strike a balance, in turn, has led to an innovative approach, within bracket, many a times followed even by this court, bracket close, which, though not strictly in tune with Order 20th, has transitioned into a regular practice by passage of time. Full stop. This contemplates a rough assessment made by a learned judge of the time to be taken for dictating a judgment after hearing in a matter is concluded, and if, in such assessment, it is likely to take more than 20/25 minutes, the learned judge proceeds to pronounce the operative part together with the outcome while expressing double inverted comma regions to slash would follow double inverted comma close, and then concludes the exercise of pronouncing the final judgment by providing the regions as soon as possible thereafter. Full stop. Having regard to the exploding docket of a majority of the high courts, learned judges consider it wise and prudent to make optimum use of judicial time by not dictating lengthy judgments in court. Full stop. This practice, no doubt, seeks to serve a salutary purpose. Full stop. People unversed with the functioning of the judicial system are perhaps unaware as to how development of this practice has contributed to saving of precious judicial time, which the learned judges invariably devote and utilize for hearing more cases that are on board in the anxiety to consider and decide as many cases as are possible during the scheduled working orders. Full stop. Burdened though with immense pressure of work and brushing aside fatigue, which is quite likely to develop, the learned judges, after retiring for the day, dictate the judgment in their court chambers or in their residential offices, either on the same day or within a few days thereafter. Full stop. The hearing having concluded not too long back, the arguments remain fresh in the mind of the learned judges, and it becomes all the more easy to dictate the judgment. Full stop. While this approach without a doubt has its own benefits, recent happenings leave us to lament that reasons for the conclusion reached are being placed in the public domain much too late, as in the case of Balaji Baliram Mupade, within bracket Supra bracket close, as well as this case. Full stop. In an attempt to save time to attend to as many cases as possible, certain learned judges unwittingly are contributing to justice being delayed in given cases, which, concomitantly, have been giving rise to criticism of unpleasant flavors. Full stop. Critics of such practice, within bracket, to pronounce the operative part with the outcome and to provide the reasons later in detailed final judgments, bracket close, could and do legitimately argue in favor of reserving judgments as required by the procedural laws if the particular case so demands, but as judges, we know, reserving too many judgments has its own pitfalls. Full stop. Once the files pile up, it becomes increasingly difficult to remember the minute details of the case and the arguments advanced by the parties in support of their respective cases, which leads to a shift to rely on the written notes of arguments. Full stop. However, if only the written notes were enough, there would be no need of oral hearing in court. Full stop. Additionally, drawing from our experience on the bench, we can safely say that inclination of learned judges to reserve judgments is invariably the course adopted where cases involving complex and intricate points of law do call upon learned judges to craft well researched and well reasoned judgments. Full stop. That apart, there are cases arising from recent enactments involving questions of law not having arisen hitherto, and consequently such questions have never been answered. Full stop. Such categories of cases demand the high courts to lay down the law in clear terms for comprehension of all concerned. Full stop. Obviously, this process is time consuming, and the time limit for delivering judgments by the high courts as laid down in Anil Rai versus State of Bihar, at times, is breached. Full stop. We have full trust and confidence in the learned judges of the high courts, since they are well equipped to tackle any kind of pressure situation. Full stop. If the pressure of work is such that in the assessment of the learned judge, the reasons in support of the final judgment cannot be made available, without fail, in 5 days, it would be a better option to reserve the judgment. Full stop.